And the degradation simply means the little pieces of DNA are kind of breaking up and you lose the ability to detect them, correct?
Beyond the scope, Your Honor.
Sustained.
And if hypothetically blood from person B gets put on that swatch later on after A has started to break down, then you might get the hypothetical that's up on the projector.
Beyond the scope.
It's an improper hypothetical. Sustained.
Now, Mr. Matheson, I want to ask you a couple of questions about the EAP testimony that you gave on redirect. You recall Mr. Goldberg asked you specific questions about the articles that I had referred you to. You remember that?
Yes, I do.
Now, let me ask you first of all, the only article that you referred to on direct was the Zajac, Grunbaum, and Krim article, correct?
That was
Relevant, Your Honor.
that was the only one presented to me. Yes.
Now, let me show you that article. Have you read that recently?
I've read this, and yes, it's been within the last several days.
And you've given testimony on redirect about the manner of degradation of an EAP, have you not?
Yes, I have.
I'm sorry, of a BA.
That's correct.
Would you agree that that particular article that you referred to, nowhere in it talks about how a BA degrades in terms of what happens to the bands, does it?
Did you ask whether or not that makes any reference to any form of specific type of degradation?
No, my question is, it doesn't tell you which bands you lose in what order when you degrade a BA, does it?
No, it does not.
We have slide C.
C.
Now, you recall yesterday we had a slide similar to this to illustrate the path of degradation of a BA down to a B, correct?
It had similarities to this, yes.
Now, one article that you were shown by, or asked about by Mr. Goldberg on redirect was the Yeshian article. Remember that?
Yes.
And you testified that article said nothing about the manner in which a BA degrades in terms of which bands disappear first. Do you remember that?
States testimony.
Rephrase the question.
You recall testifying that that article did not describe the path of degradation of a BA.
No, it states the testimony.
Overruled.
Well, my understanding of the articles, I believe it describes a different, the focus of the article is a different degradation, the B to a CB or something like that.
Okay, let me show you that article. I ask you to read the first paragraph under discussion.
Okay, under discussion, it says several studies on,
Just read it to yourself.
oh, I'm sorry. Okay.
Now, that article does describe the path of degradation in terms of which bands disappear first, doesn't it?
It does have a two-line reference to it, yes.
And it refers to that as being an analysis of other literature on the topic, correct?
It references several studies, yes.
And it says that all of those studies describe the path of degradation the way I did on my cross-examination with you, correct?
Yes, it does.
Not the way you described it, correct?
Well, Mr. Matheson did describe it in one way.
Sustained.
Not the way you described it as leading to two B bands, correct?
That's correct.
Now, you were asked a question about the book that you had referred to, the Saperstein's book. You recall that?
Yes, I do.
And the chapter of that book that you were referring to is actually written by Dr. Sensabaugh, correct?
Yes, I believe we
And he's-
mentioned that.
I'm sorry. And he's the same author that, of the article that I provided to you during cross-examination, correct?
That's correct.
And that article, the portion that you read from that article describes one other possible path of degradation for a VA, correct?
I think gave indication of that, yes.
And could you read again starting at the thus, which you read yesterday, and read down to where it says two.
Where it says what?
The next sentence where it starts with two.
Oh, okay. Am I reading this one out loud?
Sure.
Thus, one might expect the A bands in BA and CA types to be lost before the B or C bands are lost, and this, in fact, has been observed. That's the end of the sentence.
Read the next sentence.
Okay. In typing aged type BA bloodstains, for example, only the major B band, and then in parentheses, the anodal B band, may be apparent, and the temptation would be to type the sample as a B type.
And would you agree that what that says is that you might also get a path of degradation that leads you to just seeing the B2 band and nothing else?
Yes.
And then the next part of that says what?
Since it has been observed that in aged BA bloodstains, the slow B band is generally lost before the fast A band, the controlling rule is to withhold judgment on a putative B type until both B bands are apparent. If the sample is in fact a BA type, the major A band should be apparent by that time.
Would you agree that what that says is that if you have both B bands, B1 and B2, that cannot be a degraded BA?
No, I believe it says things like generally and should. It's not an absolute.
Can you cite me to a single scientific reference that says that a BA can degrade to the point where you have two B bands and nothing else?
No, I cannot.
We go to slide D, please. Now, the EAP test measures an enzyme in the blood, correct?
Yes, it does.
And it's an enzyme that's found in red blood cells, correct?
That's correct.
And our blood is made up of red blood cells and other types of cells, correct?
Beyond the scope.
Oral.
Yes,
And there's no DNA in a red blood cell, correct?
that's correct.
Our DNA is found in cells other than red blood cells, correct?
Yes,
So if you're doing a DNA test on a biological fluid that contains a lot of cells, you're only looking at what's in cells other than red blood cells, correct?
for the DNA, yes.
Now, can we go to slide E? Now, Mr. Matheson, would you agree that our hands and fingernails are made up of cells?
Yes, they are.
And would you agree that if you took scrapings from under a person's fingernails, you would expect their DNA to be in it, wouldn't you?
Their own DNA?
Yes.
If you scraped and picked up some of their skin or blood or whatever happened to be under there.
And if you did that kind of a scraping where you got cellular material from under the fingernails, if you didn't find the person's DNA, that would be unusual, wouldn't it?
Beyond the scope.
Oral.
Well, I haven't done DNA typing under fingernails, so I don't know if it'd be unusual or not.
Now, you could also, could you not, let's assume hypothetically that you have a person with fingernails that scratches somebody else who has an EAP type B. Have that hypothetical in mind?
Yes,
And a small amount of that, a person B, who has an EAP type B gets under the fingernails of person A. You with me so far?
Think so.
And you took scrapings from under the fingernails and did a series of tests on them, would you agree that when you do the EAP test, you're going to detect the EAP type B from the person who was scratched, correct?
If there's sufficient blood present, the detectability limit of the test.
Now, would you also agree that if you had a greater amount of material, cellular material from person A, and you did a DNA test, that you would detect the DNA of person A in that mixture, wouldn't you?
If there's sufficient amount, yes.
And if the amount of DNA from person A overwhelmed the amount of DNA that might have come from the small amount of blood from person B, you'd never see person B, would you?
It's beyond the scope, it's getting into DNA.
Or will. Do you understand the question?
Yes. If the quantity of DNA provided by the tissue that was scraped was significantly higher than or sufficiently higher than the blood providing the EAP, then yes.
And would you agree that you can do as many DNA tests as you want on that mixture, and you're never going to be able to prove that person B
Sustained.
isn't there?
Sustained.
I'd ask the jury to be admonished to disregard the import of that question.
They know that when I sustain an objection, that's the rule.
Now, Mr. Matheson, you talked about your control study that you used item 42 for, correct? Remember that?
I was saying that we did type item number 42, yes.
And I think you indicated that according to the article by Dr. Bedoli, that for that kind of control study to have any value at all, the sample that you're comparing it to has to have been subjected to the same myriad of environmental insults, I think is the way you described it, correct?
This is testimony.
Overrule.
Remember?
I believe on reading that, it made reference to the fact that a blood sample collected from an area where the victim is, that's known to be the victim's blood, would tend to be involved in the same environmental conditions.
But if your control sample, in this case 42 that you testified to about, was subjected to different environmental conditions than the fingernail samples, your control makes no sense. It doesn't work that way, does it?
It's argumentative. It states
Sustained.
facts, not narrative.
Rephrase the question.
In my example, the control is not a proper control, is it? If it's not, if that sample is subjected to different conditions than the one you're comparing it to.
Vegas to proper control.
Overrule.
Well, it still is going to provide information. It is blood that you know to come from a particular person. If the environmental conditions are not exactly the same, then that is something that might be considered.
Now, you were asked some questions on redirect about wet stains versus dry stains. Remember that?
I think there was some mention of it regarding the studies, yes.
Incidentally, is there a single reference in the literature or a single study that you can point to that says that the degradation pattern of a wet stain is going to be different than a dry stain?
Not that I can recall at the moment.
Now, would you also agree that 84, the fingernails in this case, there were two samples, one from one hand, one from the other, correct?
That's correct.
And one of those samples appeared to be damp because you could see the transfer of material onto the container it was put in, correct?
Yes.
The other one was dry, wasn't it?
Well, the other one appeared to be drier. It had chunks of blood down the bottom, but the tip of the stick was a little damp, or a little red, which may indicate that it had a little bit of dampness in it, but there was a difference.
There was a difference in the conditions of those two samples, wasn't there?
Well, vague and overbroad as to conditions calls for
Sustained.
speculation.
Sustained.
Would you agree that if your theory, if your testimony about a control study is accurate, it would only apply to samples that had the same conditions, similar conditions?
Vague is dissimilar.
Overrule.
I think that has to be taken into consideration, but there is still information that can be obtained.
Now, I would like to show on the Elmo I'm not sure what exhibit this is. This is the one that the prosecution did where they printed out with the arrows on it. You remember yesterday you were asked to identify I think you described them as band-like appearances
Yes.
from 42. Show you this just to refresh your memory.
Well, let's find out what exhibit it is first.
I may have written the number on the back sometime after. That may be 224C.
224C.
Right.
Let me show you 224C on the Elmo.
Why don't we give Mr. Matheson the other copy of that?
Sure.
And keeping in mind the time limitations.
Yes, we're almost done.
Mr. Blasier.
Now, Mr. Matheson, you recall that you had two arrows put where you saw what you described as something kind of like a band. Remember that?
Yes.
Now, you also testified during cross that there is something kind of like a band or something that you can see between those two arrows, correct?
That misstates the testimony, it's also in the conjunctive.
Overruled.
There is kind of a haze in that area. It's brighter than the background, yes.
And could you direct get an arrow put on that where you see that?
You need to go to the left. Left.
Can we have the arrow on the same side, please?
How about if we have it on opposite sides of the same lane so that we can determine who put what where?
Okay.
Okay, so you need to go down a little bit. Down. Right kind of in that area off to the left there. There's kind of a hazy cloud of something.
Okay, why don't you click that. Now, that is in an area that would correspond to an A band, correct?
General area, yes.
Now, I want to cover up everything except that lane. Can we print this out first? Matt's not going to cover up everything except that lane. See that?
Yes, I do.
And the technique I'm using is what you described earlier as reading it blind, correct?
No, actually, reading blind that I mentioned before is not having any information about the case. It's very difficult and really fairly inappropriate to read a plate without the controls and things present.
There's nothing on there that you, as a forensic scientist, will call a band, is there?
This is improper, Your Honor. This is not a scientifically correct way of doing it, and also the resolution's not doing that.
Sustain. Foundation.
Is there anything in that lane that appears you would call, as a forensic scientist under your training, that you would call a band?
Same foundational problems,
Overruled.
and the resolution's not good enough.
Overruled.
I don't believe I've ever testified that I identified bands in that lane, but that there were things or band-like visible areas that were showing up.
Including in the area of an A band, correct?
In addition to other areas of that lane, yes.
And would you agree that your band-like appearances are 3 areas of some sort of a cloudy thing that you've described, correct?
There's no foundation for this, Your Honor. It's all so vague. It's a cloudy thing. It's been asked and answered.
Overruled.
I'm sorry, could you repeat the question?
Yes. You testified now that you see 3 band-like things,
That misstates the
That mis-
evidence.
That does.
that you see 3 areas on there that have a cloudy-like substance, correct?
That misstates the evidence.
What do you see,
Sustained.
Mr. Matheson?
I see areas on there of different intensities of a cloud-like type of appearance.
And that doesn't look anything at all like what you found on the fingernails, does it?
Well, that's an improper hypothetical.
No, it's argumentative the way it's phrased.
It's also a picture-of-picture.
Sustained.
That doesn't look like what you found on the fingernails, does it?
Argumentative, Your Honor.
Sustained.
Does that look like the bands, does that have the similar appearance to the bands that you found under the fingernails?
Argumentative, Your Honor. Improper hypothetical.
Overruled.
No, it doesn't. If it looked the same, I would have called this with the same result, and I didn't.
All right, let's move on.
Could we have slide, Mr. Matheson, California Association of Criminalists has a code of ethics, do they not?
Yes, we do.
Let's get a look at that and read the highlighted paragraph to yourself.
Your Honor, this is relevant. Calls for hearsay.
Overruled.
Okay.
And do you agree that those highlighted paragraphs are 2 paragraphs from the Code of Ethics from the California Association of Criminalists?
Yes, I do.
And you are a member of that organization?
Yes, I am.
And you consider yourself to be bound by those ethics?
Yes.
And I'm wondering if we should print out a copy of that last demo I did.
Your Honor, I object to that because there was no foundation for a scientist looking at something that's covered up like that.
Overruled.
Can we have slide F, please?
Let's proceed with a little alacrity.
Mr. Matheson, would you agree that the Code of Ethics of your organization that you are a member of provide that the criminalist will be alert to recognize the significance of a test result as it may relate to the investigative aspects of a case? In this, I'm sorry, I got it backwards. Let me read the other one. Would you agree that one of those provisions provides that where test results are capable of being interpreted to the advantage of either side of a case, the criminalist will not choose that interpretation favoring the side which he is employed merely as a means of justifying his employment? Do you agree that that's one of the provisions of your Code of Ethics?
Yes, I do.
Could we see the next slide, please? You also agree that one of the provisions of your Code of Ethics is that the criminalist will be alert to recognize the significance of a test result as it may relate to the investigative aspects of a case. In this respect, he will, however, scrupulously avoid confusing scientific fact with investigative theory in his interpretations. You agree that that's one of the provisions of your Code of Ethics?
Yes, I do.
And you agree that there is no scientific support for your testimony that a BA can degrade to the point where you have 2 B bands remaining?
No, I do not.
Isn't that what you're doing in this case, Mr. Matheson, is violating this Code of Ethics?
Your Honor, this is totally
Sustained.
argumentative. and improper.
Sustained.
I have no further questions.
Mr. Goldberg?
Thank you. Mr. Matheson, you are, as a criminalist, bound by a code of ethics, is that correct?
I am bound of one of the organization that I belong to, and personally, yes.
And does that code of ethics also have a provision dealing with presenting inconclusive results in court?
As far as they would not be,
No, the circumstances under which you are allowed to present those results. Thought we looked at that yesterday, didn't we?
I'd have to review and find out what the provision is.
Can you take a look and see if, yeah, folks?
Please. See if we can speed this up just a little.
looking at paragraph 2E. Sir, can you read that for us?
It reads, excuse me, it reads, where test results are inconclusive or indefinite, any conclusion drawn shall be fully explained.
And when we were talking about the inconclusive results in this case, in terms of the EAP issue, did you explain at exhaustive length how you were considering and why you were considering those results?
Yes, I believe so.
Did you feel that it was necessary to do so?
Yes.
Why?
Well,
Even at the risk of perhaps boring and presenting maybe marginally relevant explanations at the length to which you went to explain them.
Well, they needed greater explanation than the conclusive results because they are inconclusive. A conclusive result is a final statement. In conclusion requires that some sort of explanation be made.
And at all times throughout your involvement in this case, have you scrupulously followed the ethical standards and guidelines that you are bound to follow as a criminalist?
I always follow them to the best of my ability.
Sir, do you consider your participation in the California Association of Criminalists to be important?
Yes, I do.
And do you consider your job as a criminalist to be simply a 9-to-5 type job, so to speak, or does it mean more than that to you?
No, it means a lot more. It's a profession. That's why I'm involved in the associations and the profession as a whole.
And this code of ethics comes from the California Association of Criminalists?
Yes, it does.
And you are one of the former past presidents of that organization, is that correct?
That's correct.
And sir, can you tell us what the little lapel pin on your lapel represents?
It's a pin of the California Association of Criminalists.
And have you at any time ever tried to interpret or misinterpret a result in this case, or any of your testimony in this case, to favor the defense?
Sustained. Rephrase the question.
Have you ever tried to present any testimony in this case in such a way as to favor one side or the other?
No, I have not.
And since you have been testifying, has any member of the California Association of Criminalists called you and criticized anything that you've said?
Objection.
It's irrelevant.
Now, Mr. Matheson, I'd like to ask you a few other questions quickly about the EAP issue. I know we've gone into it at exhaustive length, but we'll make it very rapid. As to the Yashan article that you were asked about, was that an article that studied in the sense of doing experiments on the issue of EAP degradation from BA to B?
No, it is not.
Okay. What type of EAP degradation issue was Yashan dealing with?
It was a technical note about a B to a CB.
Okay, so there's some other degradation problems that deal with EAP that we haven't really discussed at length in this case. Is that correct?
That's correct.
Oh, well, we've covered this once already.
And Mr. Matheson, scientifically speaking, does this article, the Yashan article, provide any new scientific information in terms of a study on the BA to B phenomena?
No, it does not.
Now, with respect to the Grunbaum study that we talked about, was there a sample in that study that was in fact mistyped as a B question mark that was a BA?
Yes, there was.
And did Mr. Grunbaum state that in those cases distinct band patterns were present in the cases of the mistypes that occurred in his study?
I believe so, yes.
What does that mean?
Well, I think the use of the term patterns rather than pattern indicates more than one band.
And you have stated that in your professional career, the BA to B phenomena is something that you have personally seen where there are both B bands present.
Yes.
And that includes a number of instances in this case, is that correct?
Related to this case or other cases?
Well, there are a couple instances in this case, more than one, where you believe it happened here.
Objection, no foundation.
Overruled.
Yes.
Now, you were asked about preconceived notions and the effect that that has on a scientist's judgment. When you were typing 42, the pool of blood of Nicole Simpson, had you previously been informed prior to when you did your work by Mr. Fung that that was collected as a sample of Nicole Brown's blood?
Objection, calls for hearsay.
Coming in for the state of mind on preconceptions.
It was my understanding that that's what that sample was.
And that's what you believed when you were actually doing the testing.
Yes.
So when you were actually doing the testing, did you believe that the result should be a BA?
Objection, argumentative, asked and answered.
It's leading.
What did you believe the result should be prior to doing your test?
I was expecting to see a BA.
And is that what you saw?
No.
What did you see?
I saw an inconclusive result with some kind of fuzzy areas that lined up with the two B bands. Excuse me, B bands.
You called it as a B inconclusive.
B question mark, and the conclusion was that it was inconclusive.
And sir, did your preconceptions in any way affect that result, or that notation in your reports?
No, it did not.
In the literature, have you seen a single reference that says that the only degradation route is the one that was discussed in the article by Raxall under all conditions?
Not that I recall, no.
And has anything that was brought up to you on cross-examination with respect to the EAP issue, on recross, caused you to reevaluate or reform any of the opinions that you've presented here in court on the EAP issue?
No, it is not.
Now, on the card key system, you were asked about the computer system and dealing with evidence tracking and the card key system dealing with the doors. Are those two separate systems?
I'm sorry, will you repeat the question?
You have a computer system dealing with door entries, is that correct?
Yes.
And you have a system that also tracks evidence called the SET system, is that correct?
That's correct.
Now, are those the same computer program, or are they different computer programs, or what?
They're totally unrelated and actually sit on totally different computers.
And was the card key system with respect to the laboratory, in fact, in operation from, let's say, June the 12th all the way forward to today?
Yes.
Do you know how much, do you have any personal knowledge of how much was in the blood vial at the time that it initially came to the laboratory?
No, I do not.
Now, with respect to the evidence processing room, is there any practice in place at SID to take detectives on tours of the laboratory and point out to them where everything is and where the drying cabinet is and the like?
We do occasionally give tours to detectives.
Is that done, though, for every single one systematically?
No, it isn't. If they expressed an interest, we'll be happy to show them around.
When you take tours, would you make it a point? Well, have you ever done a tour yourself?
As far as giving one?
Yeah.
Yes.
Do you make it a point when you're giving a tour to point out the drying cabinet? This is where we dry our biological evidence.
Objection, argumentative.
Overruled.
No, that's not one of the highlights of the tour.
Actually, the lab is set up for tours, isn't it?
Yes, it is. The windows into the lab, and we actually have an audio system where you can push a button and listen to a talk about that unit.
What? And with these windows, is that so that people can look inside the lab and see what's going on, and then they press a little button that gives them a description of it?
If they want to, yes.
And are these guided tours that you occasionally give to school children and the like?
Yes,
So they just go through the corridor area and they can press these buttons?
they can, yes.
All right. So if, when someone's working in the laboratory on evidence, say the serology laboratory, there's a window that's set up so that people can see in and watch what they're doing.
Yeah, most parts of the lab, you can't see into all corners of it.
All right. Now, have you ever seen, do you know whether Detective Van Adder, Detective Lang, or Detective Furman have ever had any tour of the SID facility?
I have no personal knowledge of that.
And have you ever seen either of those detectives trained in how to collect a swatch?
I don't remember if any of them have received direct training on that.
Have you ever seen them collect a swatch?
Not that I can recall.
Thank you. I think that may be just about it. I just have one moment, Your Honor. I think that that's just about it. Thank you very much, Mr. Matheson, and ladies and gentlemen.
Blasier?
Mr. Matheson, in the Grunbaum article that you testified to, where there's reference to one example of a BA degrading and being mistyped as a B, do you have any idea how many bands that degraded BA had?
Calls for speculation, pass and answer.
Oh.
Not exactly, no.
You can't tell whether there were two bands at the end or one band, can you?
Not unless the term patterns makes reference to that, but not specifically, no.
You ever called Dr. Grunbaum or Mr. Zajac to ask them?
That's three.
No
That's
questions.
three. Thank you. Nothing more on that?
No, Your Honor.
All right, Mr. Matheson, thank you very much, sir. You are excused as a witness subject to being recalled.
Thank you.
All right, and don't discuss your testimony with anybody else with regards to this case. All right? All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form... You know what the admonition is. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you with regard to the case. Don't conduct any deliberations till the matter has been submitted to you. All right, we'll stand in recess as far as the jury is concerned. All right? And I'll see counsel in about 5 minutes. Good afternoon, counsel.
Good afternoon, Your Honor. Your Honor, the most precious commodity an advocate has is credibility. Before I walked into this courtroom, you and I didn't know each other, although we passed through the same halls of a law school in Northern California, but neither of us even remembered meeting each other. When I walked into this courtroom many months ago, a lot of things were said about, from the prosecution side, to, quote, inoculate you as to how I would conduct myself as a professional and how Mr. Neufeld would conduct himself as a professional. And during the course of these many months, as any advocate, I have to build up credibility with you. I have to be accurate in what I say. I have to comport myself in a manner that is in accordance with the rules of the court. I have to make representations to you factually again and again that are accurate for you to have any trust in me, a person you've never seen, have no experience before, never worked with before. The same is true, and I know the court realizes this as a trial lawyer, with a jury. When one gets up and conducts a cross-examination, the facts ought to be there. One has to be very careful in the representations one makes, in the points one makes. Advocacy should be vigorous, but it has to be fair. I think the term applies to prosecutors in United States versus Berger, words I'm sure your court's familiar with. You can strike hard blows, but they've got to be fair ones. And I think the same applies to advocates on both sides of the aisle. So it's of great concern to any advocate to finish a cross-examination that's been carefully planned when details have been gone over with the court when one is relying on court orders, one is relying upon compliance with those court orders by the Scientific Investigation Division Laboratory, by the prosecutors, bases, in all fairness, certain lines of questions on those representations in compliance with this court's order, I think I'm entitled to rely on them doing their job diligently and making fair and honest representations. It's not too much to ask. I was set up. The record is now clear that first, when the discovery application was made for the production of original documents, mistakes were made by personnel and SID in turning over, according to them. I mean, let's just assume page 4 was the original. According to them, they made a mistake and did not turn over the original. I don't think there's any question now in terms of the record that they were very concerned about why we would be looking at these documents and what our concerns would be. And I think it's fair to say that they also knew we were very concerned about Mr. Simpson's blood vial.
Well, Mr. Scheck, let's sort of cut to the chase.
Yeah.
We know that the court made the production order.
Yes.
We know that during the course of the testimony of Mr. Fung, that page 4 appeared. That appearance was known to the prosecution prior to the conclusion of your cross-examination, Mr. Fung, and that a decision was made, it was discussed and a decision was made not to reveal that prior to the direct examination.
Missing one step. If I could bring the court's
What
attention.
one step am I missing?
All right. Between the time that I finished the cross-examination and during the production of documents, the record is clear that Mr. Hodgman notified Mr. Neufeld and myself that in the documents that they had turned over to us, one of the documents was not an original. That was the page that's been designated L16/32, and I outlined this with citations to the transcript in my letter. That came up in the cross-examination and, in fact, in the direct examination. It then became clear that before we proceeded down that last fatal line of cross-examination, that the prosecution, through Mr. Fung and Mr. Matheson, went into Mr. Fung's notebook and came out with the original L16/32. And the reason that's significant, Your Honor, is it put them on notice that their original productions might have been inadequate. And also, and I find this very troubling, I'm sure the court noticed it, Mr. Goldberg, in all his arguments that I made some kind of tactical choice not to come forward and point out a mistake to them, misstated the facts to the court on the record, saying that we were the ones that brought to the prosecution's attention that we had not received an original, therefore we should have done it again with page 4, when exactly the opposite occurred. They brought Mr. Hodgman down to this courtroom when this issue was in dispute, and Mr. Hodgman said that we were correct. They then file this parity motion with the court and repeat the same inaccurate misrepresentation as to the chain of events. It's astonishing, and make the same argument.
Well, Mr. Scheck, I'm just...
No, the reason I focus on that...
I'm just trying to cut to the chase.
No.
Counsel,
Yeah.
I sat through all of this.
I understand, and I know you know the record. The only reason I'm pointing this out and emphasizing it is that one of the problems I had with the proposed charge of the court is that it's my position that they had further notice, and this is not, court referred to it in inadvertence, I think mistake in the first instance is a fairer statement. SID made a mistake in turning over the documents, if you want to be charitable. They simply failed to turn over the right documents according to them. Then they're put on notice that where the mistake might have come from, and they didn't do anything about it. So I think there's another degree of certainly negligence or in terms of not being properly diligent in searching their files. And that's a factor to be considered in terms of what transpired subsequently to that. Now, I think the court was going to, that's the only reason I stopped the court. Now, think you want to cut to the chase and ask me another question about what, prejudice?
No, I understand your argument about the need for trial counsel to maintain their credibility before the trier of fact. I understand that. I accept that argument as being a valid argument. The next question is, you have submitted to the court a proposed admonition to the jury. I indicated to you that I would probably give 85% of that, but I was uncertain about the last sentence to be taken into consideration as to the credibility of that particular witness.
Well, I think now that what's clear is that subsequent to the act of intentional misconduct, the prosecution then tried to exploit that on the redirect examination by asking Mr. Fung questions that indicated that they had fully complied with their discovery obligations, that they didn't throw away documents or tear them up,
Right.
etc.
But Mr. Scheck, I sat through all of that.
I know. And you also indicated when I objected to it and asked for the admonition at that point again that it was overreaching and it was improper vouching and they were trying to exploit the mistake. My problem is, Your Honor, this happened so long ago. And then they then tried to exploit it and then continued with the misrepresentations. My problem is this. Unless you're willing to say something strong, it's not worth doing at all.
Ms. Lewis,
Thank you, Your Honor. Good morning.
good afternoon.
Good afternoon, it is. Your Honor, let's look at some of the pertinent facts that haven't been highlighted. Initially, Mr. Scheck apparently was at SID and examined the originals, and I'm told there are some 80 to 100 documents that we're talking about. Examined those documents, felt at that time, we now know, that there was a problem with the original not being present on page 4. Now, in that time, did he do what the defense has done consistently throughout this case, not only with the DNA labeled materials, but with every other type of material? Did he send us a letter? Did he call Mr. Hodgman? Did he do anything like that and say, did he even ask Mr. Goldberg there when Mr. Goldberg was present, do you know where the original page 4 is? It looks like it's missing. No, he didn't do that. And that was back in March. What he chose to do was to ask for all of these documents so that they could have a question documents examiner analyze them. We had no idea why they would want to do something like that, so we said, we think you ought to go to the court with that request, even though we have been complying with many, many requests of theirs that really go beyond the bounds of discovery. So they did. They went to the court, and what Mr. Scheck revealed to us during the last argument is that he made an in-camera, ex parte appropriately, offer of proof to the court, apparently, about this original of page 4. So apparently that is one reason why the court ordered the production of those originals from us to the defense for their inspection. All of this was unbeknownst to the prosecution. All we knew is that we were ordered to produce the originals, which comprised some 80 to 100 documents. We complied with the court's order to the best of our knowledge. The court already, I believe, made a finding that it was inadvertent that we had not turned over the original at that point in time. But what the defense apparently decided to do after their question documents examiner apparently verified that wasn't an original page 4 of, by the way, let's recall this is a blank piece of paper we're talking about, a blank form which has just the typewriting but nothing filled in. Once their question document examiner apparently verified that wasn't an original, they, instead of once again asking us, as they have many times throughout this case on all sorts of discovery throughout this case, instead of asking us, do you know where the original is of page 4, according to Mr. Scheck, and apparently he just corroborated what it seems like now, he planned his entire cross-examination with culminating on this big finish of accusing Mr. Fung of being involved in a conspiracy by trying to cover up the timing with regard to the transfer of blood from Mr. Van Adder, Detective Van Adder, to Mr. Fung. So what counsel did was to make a deliberate tactical choice and maneuver to try and utilize this to exploit this nothing, as it turned out, to the benefit of the defense in making it appear like there was something there, that there was some part of a conspiracy there. None of this was known to the prosecution, of course. Now, we reached a point in time during the almost tail end of Mr. Scheck's cross-examination of Dennis Fung, and that's when he elected to come up with the accusations with regard to the missing original of page 4, and it became clear to the DAs at that time that he knew he didn't have the page 4. original page 4, and that's the first time that any of us knew that there wasn't an original page 4 examined by the defense. Now, one thing the court has stated which causes me concern, and I believe the record is clear, but I want the court to be clear in the court's mind, is that when Mr. Scheck had indeed finished his cross-examination of the witness, of Mr. Fung, before we took a break, and it was during that recess that the attorneys involved sought to find out if indeed they could locate the original page 4. And, Your Honor, what Mr. Scheck said at transcript page 22776 is, Your Honor, I would like to do 2 more things, and I'm finished questioning this witness. What I would like to do is first have printed out on the Elmo a copy of the document with the erasure, different document, and then, in other words, the second thing, I would ask that each of these documents be handed to the jury so that they can examine them. Both of those items were done. The document was collected back from the jury, and at reporter's transcript, unfortunately, I have 2278, which has to be a page short, but within a few pages right after that, he said, I have no further questions. And at that point in time, the court took a recess. And so the record is clear that he had rested indeed before the recess. And at that point in time, the prosecutors looked to see if they could find where the original page 4 was, and they found it. Now, it was clear from the questioning that Mr. Scheck made of Mr. Fung that that was a tactical decision on their part to handle it in that manner. Their remedy, now this was, Your Honor, a discovery order that the court had made. The remedy for a discovery violation, well, the common sense thing, which has been done throughout this case by the defense, is to come to us and say, hey, we didn't get X discovery on an informal basis. They could have done that, and they never did that at any point in time. The next thing they should have done would be to go to the court and say, we want a sanction of some kind. We want a hearing on this missing original page 4. We want a hearing to determine if there's any impropriety on the DA's parts with regard to this original page 4. That was their remedy under the court's discovery order. Did they do that? No. They elected instead to use it in a tactical maneuver to seek to confront the witness with its absence. So what they did, and what's critical here, and what I don't believe we articulated last time we visited this issue, but what is critical, Your Honor, is that when the defense made that decision, they waived enforcement of the court's discovery order. They waived its enforcement by pursuing the course that they did rather than demanding an explanation or demanding an inquiry.
Do you know of any case authority that would characterize that situation or anything similar as a waiver?
I don't have a case, Your Honor. The Black's, we've cited in our brief the definition of waiver from Black's Law Dictionary, which really applies. I'd like to read it into the record. A waiver is defined as the intentional or voluntary relinquishment of a known right or such conduct as warrants an inference of the relinquishment of such right, or when one dispenses with a performance of something he is entitled to exact, or when one in possession of any right, whether conferred by law or by contract, with full knowledge of the material facts, does or forbears to do something, the doing of which, or the failure or forbearance to do which, is inconsistent with the right or his intention to rely upon it. Particularly that latter sentence, Your Honor, it's a lengthy definition, but the latter portion of it, when one in possession of any right, whether conferred by law or contract, with full knowledge of the material facts, which they had full knowledge of the material fact, does or forbears to do something, and they forebore to do, they forewent pursuing the appropriate remedy, which would be a discovery sanction and an inquiry of the court, and the court making inquiry of the prosecution to see if this was an intentional violation which warranted sanctions, they forewent doing that. And that's what this says. They do or forbear to do something, the doing of which or the failure or forbearance to do which is inconsistent with the right or intention to rely upon it. So their actions were indeed inconsistent with that right they had to that remedy under the discovery laws. And that was clear to us during the consultation which went on during a brief 15-minute recess. It was clear to us, it was clear to the DAs involved, that they had elected not to pursue that avenue. They had indeed confronted the witness with it. Now, Your Honor, So, Your Honor, the Black's Law Dictionary in defining waiver is directly on point here. Now, I do want to make the point that the defense has apparently on more than one occasion attempted to make a mountain out of a molehill. And, Judge, frankly, this wasn't even a molehill. This was a blank page, as the court has noted. There was nothing here. And it shows, frankly, how desperate the defense has been in some areas in coming up with a defense in this case, and it's demonstrated also by their shotgun defense. But, I mean, this is just one example of where they have tried to make something out of really whole cloth. And instead of pursuing the honest, the normal, the truth-seeking, appropriate remedies under the discovery law, which the discovery laws encourage from both sides, they decided to try and use it as a tactical maneuver. And when they did that, it backfired and it blew up in their face. And they created their own problem by having done that. Now, I do want to make a point. When the prosecution, when Mr. Goldberg, who was brought into the case after the search and seizure had been litigated, when he inadvertently referred to the airline ticket and the baggage ticket, which was evidence which was only favorable to the defense, frankly, because it showed indeed that Mr. Simpson had a pre-planned trip to Chicago where he had apparently been. When they made a big deal of that, they made a big deal of it twice. And in the second instance, in fact, Mr. Goldberg, I believe, was admonished once. I don't recall exactly what happened the second time, but again, they made a big deal of that. And what did they end up doing? They ended up withdrawing their objection to 15 and 16. And initially, when they tried to do that, I think Mr. Scheck was the first to try and do that, and it appeared to me that Mr. Cochran didn't want to give that up as a possible avenue on appeal or something, whatever, to make more of. But they utilized that the most they could to try and dig a knife into Mr. Goldberg when he had really done, he had violated the court's previous order of which he was unaware. And it's too bad that it happens. I know he regrets that it happened. But it was certainly not, pardon? He was humiliated. He was indeed humiliated by the court and degraded because of that inadvertent good faith error that he made. So the defense now is seeking to capitalize on the court. You know, as the court knows, we as prosecutors are held to a very high standard, and we're often held to a higher standard. And right, and just to finish the point with regard to the airline ticket and the baggage ticket, they made it, I think I just made this point, but they made a big point about these documents and then later stipulated that they were admissible. So clearly, you know, where was the good faith in seeking to have Mr. Goldberg humiliated and sanctioned in front of the jury with regard to that? That just shows that that was game playing. Now, the point I was trying to make is we know as prosecutors that we are obliged to the highest standard under the law, and we do the best we can to fulfill our ethical obligations. We're also servants of the people of the state of California, and we're beholden to those people to be as vigorous advocates in favor of the truth and having the truth come out as we are allowed under the law and under our ethical obligations to be. And we have done that in this case, and we have consistently tried to uphold that integrity of the oath of our offices as prosecutors. And to have the defense turn around and try and blame our side of the table for something that their own tactical error caused them to be embarrassed by is just incomprehensible. It's not fair, Your Honor. It's not fair to the prosecution. And we should not be sanctioned. It's just not warranted. The one aspect that the court had expressed concern about, I believe, is satisfied by the objective indication that the defense had indeed waived their right to rely on the court's discovery order. That is the only hole one might have considered in the previous argument that we made in this regard. But we do not deserve to be sanctioned, Your Honor. We had a limited period of time to make a very strong decision, and I believe our decision was a correct one, though I did not happen to participate. I believe I would have made the same decision because it was clear the defense had waived any other kind of enforcement when they decided to, when Mr. Scheck decided to try and make a big deal of this in front of Mr. Fung.
But waiver, to be a valid waiver, requires full knowledge, doesn't it? And if they don't know that you've got it, how is that a knowledgeable or complete waiver?
They waived it because they waived inquiry. They waived inquiry. Now,
they're not entitled to rely upon your representation, and when I say generically your representation, I mean the prosecution, these are the documents, here they are. They can't rely upon your integrity or the prosecution's integrity that this is in fact a complete set of documents.
I don't think I don't think it was reasonable reliance.
Okay.
Yeah, Your Honor.
We need to wrap this up.
Your Honor, they were entitled to seek to ascertain the truth, and they were entitled to the court's order, which the court was convinced it should give, with regard to these documents. Considering I'm told we're up to 28,000 items of evidence, pages, and including altogether 28,000 items of evidence we have turned over to the defense. They have not hesitated to bring it to our attention previously when they've been aware, when it's become apparent to them that there was some mix-up in some manner, they didn't get something that they wanted. And in this instance, when I don't know if it was Mr. Hodgman or Mr. Yolkeson, whomever discovered that we had inadvertently failed to turn over one particular original, that showed our good faith. If we knew, we would have done it. But no, I don't think in this situation. They don't come to this with clean hands, Your Honor. The Equities is not in favor of the defense on this, not when we've had a past history of dealing with them repeatedly throughout the 11 months that we've been in this, 10 months, 11 months we've been in this case now. Repeatedly dealt with them on an informal basis, so if there's anything they didn't want, Mr. Hodgman has sat, I know, Your Honor, in chambers with the lawyers with regard to all this DNA stuff on countless occasions, trying to all comply with all of this informally and trying not to have to burden the court with too many discovery matters. The court has heard a lot of them, but there's been a lot done informally that we've not had to burden the court with. So to make an issue, make a mountain out of something that doesn't even come to a molehill, it's not even a grain of sand or a little tiny piece of dirt in this instance, is really unfair, and it's unfair to the prosecution, Your Honor.
All right, I think we've used our allotted time.
I'm sorry, can I just have one moment, Your Honor?
One moment.
Your Honor, I just do want to make the final point, and we do have it in our papers that the prosecution has been sanctioned numerous times in this case, and, you know, the court made those determinations, but we have been sanctioned numerous times. We've just this morning heard of, through an offer of proof from Mr. Blasier with regard to what an expert has told them on something that we've had no discovery of. So we're still in this. And I also want to draw the court's attention briefly to the beta tapes. There was a day when Mr. Scheck said, we have no beta tapes, period.
Well,
We, the
counsel, that's
defense.
really apples and oranges. I don't evaluate all of these things as a running continuum necessarily. This is a specific order and a specific incident. So let's confine our comment to that. And counsel, you've exceeded the amount of time. All right.
All right, thank you, Your Honor.
All right, thank you, counsel. Mr. Scheck, any response that you find necessary?
Just briefly to the substance, and I won't take the bait of, I don't know why they always have to say something about my honesty every time this issue comes up when they get the facts wrong. It's, in any event, my concern is that when they came back and said, this L1632, we found in Mr. Fung's notebook, in the middle of the cross, when even an issue was made, where's the original of that document, it's undated. They were on notice that they might not have produced originals from his notebook. And it appears from the testimony very clear that the process of fielding the originals, and to the extent we can even be sure these are still originals, comes from SID, from Mr. Fung, Mr. Matheson, through the prosecutors. Then there were all these questions on redirect examination trying to bolster and vouch for the way in which Mr. Fung and Mr. Fung and SID, how honest they are, how the documents themselves can be trusted, that they don't throw anything away, that they don't tamper with them in any way. One point I think is worth noting, they keep on saying it's a blank page, and therefore it had no evidentiary significance. That was the point, that it was a blank page. That, frankly, is still the point. And we still have in those documents this whole line of proof, I know they don't like it, that there was some manipulation of Mr. Simpson's blood vial, that it was mislabeled, it was item 18, indicating it was received after the sneakers. This is still a contested issue in this trial as to the amount of blood in the vial. It's going to be a contested issue all the way to the end. So I think that this is a significant point as to the credibility of the witness. And I don't think there's any issue that they not only intentionally did not comply with the order, they didn't give us a chance to deal with it as an advocate can. They tried to attack not only our credibility of advocates, but most importantly, they tried to vouch for the credibility of the way they handled discovery and credibility of the witness on this issue of of real importance to the case. So those are the elements that it seems to me were that I think they have compounded since this issue first arose, and that the court really should take care of in the order. It's clear they misled us. They were on notice of the source of their mistake. They didn't take any action to change that, if it indeed, is the original. They exploited it intentionally. They then, on redirect examination, vouched for the credibility of the witness. So I think that we're entitled to the elements that I think we're missing from the court's charge about their violation of law. In the first instance, their intentional misconduct in the second instance, they're misleading us, whether it's by mistake at first and negligence certainly at the least second. And finally, that their efforts, their intentional misconduct was the way they conducted the redirect, try to vouch. I think we're entitled to that element of the charge, that the jury may consider the failure and the intentional failure to bring this to the defense's attention on the credibility of the witness, because it was it did reflect on the witness, and it was something that they were vouching for in terms of the proper handling of the documents and discovery. So I think we're entitled to all those elements. And again, I urge the court, they delayed this by every means possible. So now we're really at a point that, again, if the court is not going to give a strong charge on this, it's not worth doing. It's more of a problem for us than it's worth.
All right. Thank you, counsel. All right. I'm going to review some of the commentary in the transcript before I issue the ruling on this. Then at that point in time, after I issue a ruling, I'll give both parties an opportunity to look at that before I go forward. All right. Also, I'd like counsel to consult in the meantime about what piqued my interest earlier today, the comment about by Mr. Blasier about in the offer of proof regarding EDTA testing, whether or not there's a discovery issue there. That should be handled informally first. If I need to take it up, we'll do that on Monday. All right.
I'm sorry, Mr. Blasier mentioned to me he had a plane. He was hoping to get out by noon. I don't know if he's still here.
No, I know. But I understand, since we have 5 other able lawyers here, that somebody here knows about this. All right, Mr. Neufeld?
When would you like to take up the issue of the DNA boards for Dr. Cotton, who I believe will be beginning to testify sometime on Monday?
All right, have we displayed those?
We had a viewing by the defense of the various boards, and I believe Mr. Neufeld indicated there may be some objections to some of them. They are upstairs and somewhat voluminous. At least they're heavy.
All right, then why don't we do this 8 o'clock Monday?
Well, if they have to change the boards, I don't know if that's, we can indicate, I don't know.
Well, I mean, are counsel available this afternoon? Mr. Clark?
Did the court have a particular time in mind?
Well, I'd like to get some lunch one of these days. You want to come back, say, at 1:30, 2 o'clock? Informally, and we'll just take our coats off and look at these things and see what we got?
That's fine.
All right, 2 o'clock.
One of the printouts that was not previously marked of the blood vial, and I don't know whether we need to separately mark our little red.
Let's do that Monday.
Okay, so can we take them, or should we leave them in the court's custody?
No, leave it in the court's custody.
Was that to be 1:30 or 2, Your Honor? I'm sorry.
2 o'clock, and it'll be informal. We won't have a court clerk.